change a little bit here and there means that I can use others registered trademark already. Hi, welcome back. I'm Lawrence. I'm the founder of IP Genesis. And in this series, we are going to walk through everything you need to know about trademarks, starting from the basics, okay? Whether you are a business owner, you are an entrepreneur, or you are someone just curious about IP, this episode is designed for you for a solid foundation. So today we are going to cover the essentials. What exactly is trademark and why is it important? How can it protect your business? And by the end of the session, you will have a clearer understanding of how trademarks works and how they can help safeguard your brand identity. We will keep things simple, practical, so that it's easier for you to understand. My goal is to make sure that today you can walk away with actionable insights that you can start protecting your trademark and applying to your business right away. If you find this episode useful, right, feel free to subscribe and then share it to anyone that can benefit from this. And we will go into the basics of trademarks. Now we are settled in. Let's start from the basic. What exactly is a trademark? We have often been asked, what is a trademark? Do I need a logo to register a trademark? Or do I need a fancy design to register a trademark? Can I register my face as a trademark? In simple terms, a trademark can be something that identifies your products and services, and then it sets apart from others. But this is at an essential level. At a higher level, a trademark is actually part of your branding, your brand's identity, which is a unique fingerprint in the marketplace. It's actually help you to distinguish yourself from your competitors. Trademark is actually an umbrella term. It includes your company's name. It can include your products and services name. It can be your logo. It can be your slogan. It can be your portrait. It even covers non-traditional trademarks like sound, colors, scent, and shapes. For example, the golden arch of McDonald's, that is a trademark. The swoosh on a pair of Nike shoes, that is a trademark. Even the name Coca-Cola itself is a trademark. These are the things that people can instantly recognize and associate with the specific companies and the products and certain level of quality. Generally, there are different types of trademark that you can have. The first thing is like a word mark, which is your brand name, for example, Apple or Google. But it can also be a logo or symbols, okay, like the Adidas 3 stripes. Sound can be trademark, like the iconic Intel jingle sound, okay? These are the things that made out what we call as a trademark. They actually play a huge role for people to recognize your business. Let's go back to our questions earlier. Do I really need a logo or a fancy design for my trademark? Not necessary. It can as simple as go for a brand name, a simple words. Okay. Can I register a trademark for my face? Yes, you can. A portrait can be registered as a trademark. It's actually quite a big step, but it's interesting. And there are quite a few brands that have registered their face as a trademark. If we talked about trademark, we will notice that people will mention there is a symbol of a trademark PM and the R is a circle, which is put together with their trademarks. What is actually the difference? Actually, both are meant for a symbol representing a trademark, to indicate a trademark, but there are differences between them. We can only use the R with the circle symbol for registered trademark, and then the TM sign, which is actually meant for unregistered trademark and the pending trademarks. Let's move on to the next important thing is what is the importance of a trademark registration? A trademark registration is meant to protect your brand's reputation and value. A trademark registration ensures that nobody can copy your brands and then write on your reputations by using a same or similar name, even damage your brand's credibilities. Imagine you spend years or even tens of thousands or millions in building your business, delivering the good qualities, products and services. After that, your brand name has become well-known and trusted by your customers. Suddenly there is a competitor that come and imitates your brands and then sell at a lower price at an inferior quality. At this point, if you wish to stop the infringers, you need your trademark registration to prove your legal ownership and then enforce your rights. Worst case scenario, if you don't register your trademark first, your competitor take your trademark and then register under their own name. This would actually cause you to lose the ownership of your trademark. In this situation, all the resources that you invested in developing and marketing your brands, right, will be in vain. So without a registered trademark, you will have less control if someone tries to use your brand's identity. Even if you have been using the trademark for years, right, without a registration, it will become harder for you to defend your trademarks. So a trademark actually is a legal backup for you to protect your brands from copycats. The last good thing about trademark registration is the protection is forever. What you need to do is once the registration is successful, you just need to renew every 10 years. These are the good things. Once you got it done, it is forever yours. When there is such a good things, surely there are some requirements to be fulfilled. Now we understand why the trademark are so important. Let's talk about basic requirements for registering a trademark, because surely there are legal requirements to be fulfilled. It is not just a matter of coming up with a cool name or a logo. Just because the name created by you doesn't mean that it can be qualified for legal protections. There are a few things that you need to keep in mind when you are creating a new brand. The first and foremost, your trademark has to be distinctive. Basically, it needs to stand out and unique. People can easily identify your brands from other competitors. Ideally, you should come up with your own invented words, but if you can't, you have to use an existing word. Then it's better that the word or the name is something not commonly used within your industry. Okay, it is still best that you choose a name or words that totally has no meaning. Secondly, avoid using the names which is describing your products and services, or even have any relevance to your products and services. For example, if you use Apple as your trademark, it is perfectly fine if you are using the word Apple to sell computer or cell phone. But the thing is, if you use Apple to start selling Apple, that would be a problem, because it will go against the rules on absolute ground for refusal, because this is describing what you are doing. Okay, if you have no choice, you have to use an existing word. You have to keep this requirement in mind. The other requirement is make sure your trademark is not confusingly similar with any other earlier trademark. Earlier trademark means that those trademarks that can be already registered, or even those that have been used in the market for years. Before you apply, it is always a good idea to check before you file the application, if is there any similar trademark in the trademark office database or not, so that you can avoid unnecessary hassle when it comes to registration, because it is always good that you know all the risks beforehand before you even proceed with filing the application. Yeah, the last thing is you also need to make sure that your trademark is something that can be legally protected. For example, there are some legal requirements that specifically mention there are some things that cannot be registered as trademark. For example, a place name, a country's flag, a country's names, or even some things that in a certain countries they find some elements which is offensive. We better check all this out before you go and file a trademark registration. All this can be done by just appointing a competent local trademark attorney to go through the requirements with you. One thing we need to aware is that when we file a trademark application, other than the trademark itself, there is another important information is the scope of protections of the trademark. When we file a trademark applications, we will have to list down the goods and services attached to the trademarks, which is sold under the trademark. This would actually determine the scope of protections of your trademarks, which is why we need to be comprehensive when you file the application. Let's say you listed 10 items in your initial applications, and then eventually you find out, hey, I probably need to add another 5. In that point of time, right, you have to file a fresh applications already. It is best that before you file an application, you sit down and then list down all the potential goods and services that you are selling at the moment, and then those that you are going to sell in the next 2 or 3 years. And then you put that into your application. That would actually determine the scope of protections of your trademarks. For example, today I register my trademark for selling coffees. I put in all the coffee related products. Arguably speaking, if somebody else use my trademarks and they use it to sell car spare parts, he might be able to get away from trademark infringement because he is not infringing my rights. It's very important that you have to list down all the products and the relevant services, and then make sure you have maximize your protection. For example, if you are selling coffee, you might want to cover those classes that involve cafe, and also those that pastry related class or products. This is something that you need to plan when you prepare your trademark application. Now that we have covered the requirements, let's walk through the actual process for trademark registration. You know why? Knowing the steps ahead, it can help you avoid delay and unnecessary mistakes. The first thing we do is do a trademark search. Check the registry database, see if there is any other trademark which is confusingly similar with you. If you found any, then you evaluate the chances together with your trademark attorney. Of course, they will tell you that whether chances of overcoming the refusal is good or not. If you feel like you don't want to take the risk, then at that point of time, you can try to come up with another name. Conducting a trademark search is essential before you file a trademark, although it's not compulsory, but it's always the most advisable thing to do, so that you don't have to know the result few months later. Once the trademark search is done, then we can go ahead and file the trademark application. Usually we file the trademark applications, right? The key information to be included is the trademark itself, the list of products and services, and then after that it will be the name who will be owning the trademarks, because the ownership is very important when it comes to IP protections. You need to specify who is the true owner of the trademarks. The owner part, it can be individual, it can be company, and it can even be a joint ownership. So it's up to you to decide. And make sure in your application everything is complete and accurate, because even a small errors it could slow things down, or the worst part is you might be protecting the wrong things, because you might get the registration done, the process could be completed, but if you include the wrong information at the beginning, then the entire protections might go wrong. You might end up protecting the wrong thing. So this is something that you need to pay specific attention when preparing your trademark application. Once your application is submitted, you will be on the parts that examination by the government trademark office. The trademark office examiners, they will review applications to ensure that your applications comply with all the legal requirements. They will check whether your trademark is distinctive or not. They will check whether it's descriptive or whether it's actually against any other laws, which is those requirements that I mentioned earlier. If the examiner finds any issues, then they will issue something, we call it as office action. This is basically a request for further information, or it's a refusal that they say that your trademark is refused because maybe they find it similar to somebody else, things like that. Of course, you are always given the chance to respond to this kind of office actions, but that would actually prolong the application. This is a very important step because during the response, you might need to arrange some strategy in responding. You need to be careful with that. This is not the part that we would advise you to discuss with your trademark attorney. Once the examination is done, assume it's getting approved by the examiners, then the next step is publication. Your trademark will typically be published in the government's trademark gazette. It depends on the countries, on the period of publications. It could be ranging from 30 to 90 days. It depends on the country. The purpose of this publication is to give the third party or any public to come and oppose your trademark application if they believe that your registration conflict with their rights. If during this period nobody come and oppose your registration, congratulations, your registration is complete, and then you will receive a certificate of registration. Like said just now, the protection period for a trademark is actually forever, but you have to renew from time to time. Most of the countries, you will need to renew for every 10 years. Timeline for registration, it really depends on the trademark office. It can be ranging from 6 months to 18 months up to 2 years, depending on the workload of each trademark office and then how efficient are they in conducting the examination. But definitely it is not an overnight process. Even if those more countries which are more efficient, they will take a few months at least. Now we know that it is a lengthy process, so it is best that we know what are the common mistakes to avoid when you do your trademark registration. What are the most common mistakes that we have encountered over the years? First thing is skipping the trademark search. Okay, some of the clients, in order to save money, they didn't want to do the trademark search, but end up they only know the similar mark after a few months later when the examiner come back with their refusal. And then the second mistake is the goods are actually too vague. Sometimes we have to be specific in describing our products and services. For example, if you just put fashion apparel, this is something that too vague, too wide, because the words fashion apparel, it can actually involve a few classes. Bags or shoes or clothes, these could be in different classes. And then even things like shoes, they can be in different, caps can be in different classes. We need to be specific in our goods. Even if you mention the words, for example, the words like food and beverages, this is considered very vague as well, because the goods under food and beverages, right, they are very wide. Some of the foods, they might not in the same class. If you are talking about food related classes, right, easily we will have 3 to 4 classes. We need to be specific when it comes to goods and services. If you're selling coffee, you just mention it's coffee. If you're selling pastry, you have to mention pastry. If you are preparing prepared meal, then you have to put in it's a prepared meal. Third most common mistake is not responding to office action on time. Because sometimes when the examiner issues office actions or requests more information, if the application is handled by some of the client, if they DIY the applications, they might not receive the application, or they didn't notice that there is a deadline mentioned in the letter. So they probably just keep the things aside and then wait until when they are free. But usually there is a deadline of probably 1 to 3 months for you to respond. So by the time they come back to visit the application again, they probably is too late already, or maybe they have missed the deadline. In short, trademark registration is a very detailed process. You will need to follow the step carefully and then to avoid unnecessary common mistakes. The more important thing is we need to aware is trademark protection is territorial basis. Let's say when you register your trademark in Malaysia only, then your protection is only limited to Malaysia. If somebody use your trademark in other countries and you have not registered, it will be very difficult for you to enforce the rights over there. This is why at this point it's very important for you to think ahead to know that which country you are interested to expand so that you plan beforehand. You know exactly when you are going to register the trademark in those countries. When it comes to international trademark registrations, the good news is there are some systems that are available in place. Fundamentally, you should still register the trademark one by one in those countries. There are some systems that are available for you to go and register your trademarks using that system. For example, the most famous one is the Madrid systems. This is the systems administered by World Intellectual Property Organization, WIPO, where you can use it to register a trademark in a few countries. Instead of filing one by one, you just need to file in one office, which is WIPO, and then during your application, you can designate which country you want to go. So Madrid system currently they cover more than 120 countries. It is a great option, but the streamline is definitely, the process is definitely streamlined, but you have to remember, even if you use a Madrid system, each country has its own rights to approve or reject an application. Some people may misunderstand that a Madrid system grant automatic protection in all countries, but it doesn't. You still need to designate which country to go when you file your Madrid application. And then eventually each country, they still have their own rights to either approve or reject your application. Another option is regional trademark application, but this is not available in every place. For example, EU, European Trademark Office, when you file an EU application, you will automatically grant protection in all the member states. So this is different from Madrid. When I found Madrid, each country, they have their authority or discretions whether to approve your application. But under EU trademarks, the moment you get it approved, it will automatically granted protection in all the countries. This is quite a cost-effective way to go forward. For those countries that are not covered by Madrid or regional application like European trademark, then we still have to go by conventional filing, which is filing country by country. What is the best practice when you comes to international trademark protections? The first thing is that you have to start from the home country, then slowly expand according to the countries that you are interested or you are going to cover in the near futures. Okay, so if you are not sure where to start, you prioritize on those countries which have higher populations and higher chances of counterfeit or brand imitation. For a business that's looking for global expansions, right, it is always good to consult an IP lawyer to help you to develop a strategic plan on how to protect your trademark internationally. They can help you to navigate different systems and then they will let you know when to utilize that kind of systems. Now you have your trademark registered already. Let's talk about trademark infringement. What if somebody infringe your trademark and how can you enforce your rights? Once you have gone through the effort of registering your trademark, the next important thing is to protect it from unauthorized use. So what exactly is trademark infringement? What can you do if it really does happen? In simple terms, trademark infringement is when somebody use your trademarks or use a trademark which is similar to yours without your consent. And then that actually could lead to confusion among the consumers. If somebody else use a trademark or name or logo that is similar to you, then the consumer might think that they are buying from you when they are actually buying from someone else. That actually can hurt your business and dilute your brand and then damage the trust that you have built with your clients all the years. So how do we enforce if somebody copy your brand? So the first step is always to observe the infringer first. You will need to collect evidence. So don't rush into confronting the infringer first. You have to collect as much information about the infringement as you can first. You have to find out where is the infringer, identify who are they, and then once you have enough information already, then you can get consultations from your IP lawyers. He will actually help you in start sending cease and desist letter, which is a formal notice in telling the infringer to stop using your trademarks. So the letter will usually explain the situation, your rights, and then give him a chance to correct the issues. If the cease and desist letter doesn't resolve the problems, then you have to take further step, which is to file a lawsuit for trademark infringement, and then this could lead to a court actions. The court will order the infringer to stop using the trademarks, and then in some cases you might be entitled to damages. But in this case, it is important for you to act really quickly if you notice somebody is infringing your trademark, because delay in taking action might actually weaken your claims. You might risk losing some of your associated rights with your trademark if you don't enforce them properly. The moment you notice somebody else is infringing your trademark, don't wait. Quickly collect enough information and then seek consultations from your IP lawyer, and then we plan ahead what to do moving forwards. Let's finish off today's sessions with fun but important information. Let's debunk some common myths about trademarks. There are some questions or misconceptions that I have heard all the times from business owners. Let's clear it up now so that it can save you some headache in future. The myth number one is about there is a single registration for trademark that can cover the whole world. While we hope to have this kind of convenience, but in fact, there is no such systems available at the moment. Like I said earlier, we have to go country by country or even use those available systems that we can leverage on to register our trademark, such as Madrid systems and then the regional trademark registration like EU IPO. The next myth is I can always register somebody else's trademark which not yet been registered. This is not true. They already been using the trademark for quite some time, just that they forgot or haven't registered as their trademark. Even if you register your trademark now, there are still other legal remedies that they can rely on to take action against you and then to regain the ownership of their trademarks. It is not always that if when you conduct a trademark search, you found out somebody else haven't registered their trademark and then you can go and register there. It doesn't work that way. There are still ways that they can take it back. Third myth is some people think that the trademark need to be renewed every year. Not necessary. Trademark is a good investment. Once you get it registered, what you need to do is renew every 10 years only. The myth number 4 is change a little means that there is no infringement. The most commonly lines that we heard from our client is change a little bit here and there means that I can use others registered trademark already. Totally wrong. It doesn't matter how much you have changed. It's all about the elements of confusion. If the changes that you make is sufficient to cause confusion amongst the publics or the consumers, then you might actually get caught for trademark infringement already. Myth number 5 is they might thought that trademark registration is expensive and only for big companies. In fact, it's not. If you can afford to buy the computer, means that you can afford the trademark registration. Yes, you are allowed to be surprised, but not uncommon to see big company to go extra mile to register everything under the sun. But if you are just starting up, it's not necessary. You can start from the basics, your name, and then when you are ready, you move forward, cover your logo, and then even cover those other relevant class. So there are always a more economic ways in doing these things. So you don't be hindered by the so-called cost of registration of trademark. It doesn't always cost you a bomb. It can be adjusted according to your budget. So, conclusion. We have covered quite a lot today about trademark. I hope you walked away with a better understanding on how they work and why are they important for protecting your brands. Moving forward, we will be sharing more about others' IP. Maybe we will cover more other topics about copyrights and patent as well. So stay tuned. If you have any questions, please come and reach out to me directly. You can visit our website, you can PM us, or you can directly WhatsApp us. I hope you enjoyed today's video. Thank you very much for watching. If you find it helpful, please share and then like and subscribe our videos. Okay, I will try to do more video like this so that I hope that we can help the entrepreneurs community. Thank you very much.